Okay, starting the recording. It is January 1st. Happy New Year's, everybody. And we left off in, I want to say, it's a chapter. Wait, did we leave off at chapter 7? Was 7 the last thing that we read? Let me see. Nope, we left off at chapter 8. Okay, so, but we still had a few of the appendixes that we still needed to read.
You had mentioned chapter 9 in the room there. Was that what you meant?
No, chapter 9 is what we will read next, but we were still in 8 in Appendix G. What is it? G30 and G34 we hadn't read yet, which was still in chapter 8, but we were running out of time. So why don't we...
We're just doing the appendixes from chapter 8 and then chapter 9. Okay.
Yep. Okay, so G, where was that? Already read that one. Read that one. Okay, so this was in regards to... Okay, so the first one was regarding the lease and rental agreements. So...
Sorry, Dawn, could you tell me where you are?
Yeah, so...
Use my book now.
Oh, okay. So I'm going to read Appendix 34 and G34, and then I'm going to read Appendix G30. Then we're going into Chapter 9.
Okay, thank you.
Yep. All right, so G34. Okay, so... Sample Format 34 Rental Agreement. This is taken from a standard rental agreement and edited to suit the needs of the trust. Lending institutions. Some lending institutions need to see a rental agreement whether it is the trust or the grantor who needs to borrow funds. Further, the IRS is satisfied if the trust grantor rents the property placed into the trust. This agreement formally sets up the relationship among the grantor, the trust, and the trustees, providing another example of how good fences make good neighbors. After a residential property is exchanged into the trust, create a rental agreement. Building corpus. This setup allows those with less money to put funds in trust instead of needing a large cash flow to support the expenses of upkeep. The grantor can put the home in trust and pay rent. This both builds up corpus in the trust and allows the management trust to handle the appropriate expenses. The agreement is a specific example previously tailored to conditions applying only to this home. The details here are not fitting to other agreements. Please edit accordingly. So it has the parties. The landlord being Lawndale Direct with their address and their phone numbers. And then on the other side is tenants, Joseph and Sandra G. Allen, their address and telephone numbers. And below that it says property address, 6849 East Lincoln Place, Canton, Ohio, 50402. Description of property, 4-bedroom home, about 3,000 square feet, with a detached separate garage 20 feet by 26 feet to be used as a studio. 1. Rental amount. Beginning August 34th, 2004, tenant agrees to pay landlord $2,400 per month in advance on the 5th day of each month. Said rental payment will be delivered by tenant to landlord or his named agent to the above address. Rent must be received by the 5th of each month by landlord. or named agent to be in compliance with the terms of this agreement. 2. Term. The property is leased for 10 years, expiring the last day of April 2012, and continues on a month-to-month basis until tenant and landlord review this rental agreement and come to different terms and understandings. 3. Initial payment. Tenant pays $2,000 as security and the first month's rent of $1,500. Said payment will be in the form of cash, personal check, or cashier's check due before occupancy. 4. Subletting or assigning tenant agrees not to assign or sublet the premise or any part of it without first getting written permission from landlord. 5. Utilities. Landlord pays for water. All other monthly maintenance services are the responsibility of the tenant. 6. Parking. Tenant may use the driveway and the garage. 7. Condition of premises. A. Landlord and tenant agree the premises are in need of upgrade and repair. Landlord pays for all upgrade and repair on approval by written estimate. B. Landlord pays contractor directly or repays tenant, whichever is easier, for all invoices under $1,000. Invoices over $1,000, landlord pays directly. C. Tenant has inspected the property and premises have been cleaned, and all items, fixtures, appliances, and appurtenances are in complete working order. D. Tenant will be responsible for the 1. Cleaning or repair to any plumbing fixture where a stoppage has occurred because of misuse. 2. Prepare a replacement of the garbage disposal where the cause has been a result of bones, grease, pits, or any other items which normally causes blockage. All right, now we're back to 8. Changes. A. Tenant will not make any changes to the property without the permission of the landlord. This includes, but is not limited to 1. Installing aerials, lighting fixtures, dishwashers, washing machines, dryers, or other items. A2. Tenant will not change or install locks, paint, or wallpaper said premises. A3. Tenant will not place cards, signs, or other displays in a window or any other place where they can be viewed by other residents or by the public. A4. Home improvements and alterations. 9. Bad checks. Tenant will repay landlord for bank charges. 10. Noise and disruptive activities. Tenant, guests, and invitees will not disturb, annoy, endanger, or inconvenience neighbors, the landlord, or his agents or workers. 10A. Tenant may not violate any law, nor commit or let waste or nuisance in or about the property. 10B. Tenant will not do or keep anything on outside public parkway. Visitors and tenants cannot park outside the property on the public road. 11. Landlord's right of entry. Landlord may enter and inspect the premises during normal business hours and on reasonable advance notice of at least 24 hours to tenant. 11A. Landlord is allowed to make changes, repairs, and maintenance that in landlord's judgment are necessary to perform to keep the property in good condition or to increase its value. 11B. In addition, landlord has all right to enter under Civil Code Section 1954 if the work performed needs the tenant to temporarily leave the unit. Then tenant will leave for this temporary period on being served 7 days notice by landlord. 11C. Tenant agrees that in such event that tenant will be compensated by a matching decrease in rent for those many days that tenant was temporarily displaced. 11D. If the work to be performed needs the tenant to perform certain tasks, then those tasks will be performed on serving 24 hours notice, written notice by landlord. Example, removing food items from cabinets so the unit may be sprayed for pests. 12. Repairs by landlord. Where repair is the responsibility of the landlord, tenant must notify landlord with a written notice stating what item needs servicing or repair. 12A, tenant must give landlord a reasonable opportunity to service or repair said item. 12B, tenant recognizes that rent will not be withheld unless a written notice has been served on landlord, giving landlord a reasonable time to fix said item within the means of Civil Code Section 1942. Under no circumstances may tenant withhold rent unless said items forms a large breach of the warranty of habitability, as stated in Code of Civil Procedure Section 1174.2. 11C, the maximum the landlord is required to spend is $5,000. 13, domesticated pets are allowed, but the landlord must be told. 14, furnishings. The premises are unfurnished except for the washer and dryer. They will be replaced by the landlord as needed. 15, keys and storage. 15A, storage privileges for the tenant are included. 15B, tenant receives 2 sets of keys to be returned when premises are quit or tenant will be charged for replacing the locks. 16, insurance. Tenant may keep a personal property insurance policy to cover any losses sustained to tenant's personal property or vehicles. 16A, it is acknowledged the landlord does not maintain this insurance to cover personal property damage or loss caused by fire, theft, rain, water, overflow, leakage, acts of God, and or any other causes. 16B, it is acknowledged the landlord is not liable for these occurrences. It is acknowledged that tenant's insurance policy shall solely indemnify tenant for any losses sustained. Tenant's failure to maintain said policy shall be a complete waiver of tenant's right to seek damages against landlord for the above stated losses. 16C, the parties acknowledge that the premises are not to be considered a security building, which would hold landlord to a higher degree of care. 17, termination of lease rental agreement. 17A, if this lease is based on a fixed term pursuant to paragraph 2, then at the expiration of said fixed term, this lease shall become a month-to-month tenancy on the approval of the landlord. Where said term is a month-to-month tenancy, either party may terminate this tenancy by the serving of a 30-day written notice. 17B, if the property is sold during the lease term, the landlord cannot terminate the lease. 18, tenant must defend landlord from claims arising from tenant's use. 19, hazardous materials are limited to studio. 20, tenant must keep premises from construction liens. 21, disputes must be resolved first by mediation per the attached mediation arbitration agreement incorporated herewith as part of this agreement. 22, leases subordinate to any mortgage of the landlord. 23, taxes. Landlord pays real estate taxes and assessments on property. 24, tenant must comply with government regulations. 25, validity, severability. If any provision of this agreement is held to be invalid, such invalidity will not affect the validity or enforcement ability of any other provision of this agreement. 26, attorney fees. In the event action is brought by any party to enforce any terms of this agreement or to recover possessions of the premises, the prevailing party shall recover from the other party reasonable attorney fees. It is acknowledged between the parties that jury trials significantly increase the cost of any litigation between the parties. 27, jury trials require a longer length of time to adjudicate the controversy. On this basis, all parties waive their rights to have any matter settled by jury trial. 28, notices. All notices to the tenant shall be deemed served on mailing by first-class mail, addressed to the tenant at the subject premises or on personal delivery of the premises, whether or not tenant is actually present at the time of said delivery. All notices to the landlord shall be served by mailing first-class mail or by personal delivery to the manager's apartment or to and the address of the Sterling Management Company. Tenant must acknowledge receipt of mail. 29, additional rent. All items owed under this lease shall be deemed additional rent. 30, additional terms. 31, entire agreement. The foregoing agreement, including any attachments incorporated by reference, constitute the entire agreement between the parties and supersedes any oral or written representations or agreements that may have been made by either party. Further, tenant represents that tenant has relied solely on tenant's judgment in entering into this agreement. Tenant acknowledges having been advised to consult with the independent legal counsel before entering into this agreement and has decided to waive such representation and advice. Tenant acknowledged that tenant has read and understood this agreement and has been furnished a duplicate original. Then it has below that in witness thereof, and then the name, title, signature, and date of the trustee for the Lawndale Direct and the two tenants, Joseph and Sandra. No representation is made as to the legal validity or adequacy of this agreement. If you desire, consult with an attorney before entering this agreement. And that was that. Then 34 was,
Question.
yeah.
Okay, so I was just looking at the beginning. So who actually becomes the landlord on that? Does that confuse
The trust.
me? Yes, but it says here, landlord or named agent. So would it be the trustee?
Yeah, so that would be the Lawndale.
Oh, okay. I see here. I'm sorry. Okay, that was the first one which you answered. I should have looked up. And then the other thing I wanted to ask was, okay, so you see where it says building corpus? It
Yeah.
says this setup allows those with less money to put funds in trust. Instead of needing a large cash flow to support the expenses of upkeep, the grantor can put the home in trust, which I understand, and then who pays the rent? It says and pay rent. The house pays rent or a grantor? That confused me. Maybe I'm just
Which
overreading.
number is that under?
It's right in the beginning. It's before the numbers.
Oh.
Building corpus.
Oh, building corpus. This setup allows those with less money to put funds in trust instead of needing large cash flow to support the expenses of upkeep. The grantor can put the home in trust and pay rent.
Well, who's paying rent?
So, because it's whatchamacallit, Joseph and Sandra Allen are the trustees.
Well, they're the tenants, aren't they?
Well, they're the tenants, but they're also, I believe, they are in the trust as well.
Where did you get that? Where did I leave that?
Well, we'd have to go back because I could have sworn when they were talking about.
So then, if they're the let's just say, for argument's sake, they are the trustees. So are they? So that confuses me because then they would be paying rent, but they're also the trustees.
Well, okay. So the way I see it is that so they're the trustees of a trust, and then the property is in the trust. But they still want to live in the property. And because there's not really a cash flow going on in that particular trust, then the rent that they would be paying is going to go into the trust to help make payments for any fixes and stuff like that.
Plus, that would be a little bit of cash flow building.
And that's an additional cash flow. So it's not like me where I'm in an apartment, I'm paying my money to somebody else to make, to pay off this property stuff. it would be like I owned this property, then I put the property in a trust. And so, but the trust isn't really funded. So what I'm going to do is I'm going to take my own money and I'm going to pay rent, quote, in little air bunnies. I'm going to pay money into that trust. So that trust now has money to fix any problems that happen. So that's like keeping it in the family.
Right, but plus it's probably cash flowing a little bit into the trust.
Yeah, it builds up unless, of course, there's, a fix that you all know property is always need to be fixed at some point. But let's just say it doesn't, it runs great for like 5 years, or if they did have to fix something, it was like itty bitty little. So, and then say a problem happened that wasn't necessarily a quote landlord issue, then they could just pay the money to have their home fixed out of their pocket. And the trust would not have to pay for that, but they would pay for it. So it's like a win-win.
I'm wondering, that's actually pretty good. But I'm wondering, do you think that you could do this if you owned a home, but you had a mortgage on it, but it was a rental, and the rent is paying the mortgage and also cash flowing? I'm wondering if you could put that into the corpus.
Absolutely, you can put a home that's under mortgage in there, because now it's the trust's responsibility to pay the mortgage, not yours. But your rent is going to go into that trust, and then that trust will pay off that mortgage. Yeah.
Very good. Thank you.
Okay. So now we're going to go down. I'm going to use some of that stuff for the new sublease that I have to write up for the new roommate. Okay, this one is under management. It talks about this contract spells out what the management trust handles. So that will be G30. Oh, wait. I'm marking these as we read them, so that way if it pops up again saying that, Appendix G 34, then I can know that we've already read that one. We don't have to reread it. Like the marriage one, Judy. Okay, format 30. G30. Management agreement. The need to authorize formally the management trust to act for the asset holding trust. A specific contract is needed. Searching through several legal references did not yield the needed information. Finally, a list of responsibility of the management trust for the asset holding trust, combined with paragraphs taken from other documents, allowed this agreement to come into being. Asset holding trust management. Here again, only the first and last page prove the authority to third parties.
Hey, Dawn,
Yeah.
you were showing the appendixes before when you were reading them. Is that?
Yeah, I was doing that for things that were visually needed, but for this stuff, like I might be able to do it for the next section. Okay. But and you have the PDF, don't you?
Right. I just have to figure out where the appendix is, but maybe
it's on. Look to page 428. Not the PDF pages, but the actual book page number is 428.
Okay. Thanks.
Yep. Here again, only the first and last page prove the authority to third parties. Use this contract when buying and selling real estate. Because the asset holding trust name is recorded at the county for real estate, both the real estate agency and the escrow company needs authorization to send the funds for the asset holding trust into the management trust checking account. In the following example, this management contract is for the S.M. Myers Trust. It is unlikely the equipment is registered under the name of SM Myers anywhere except in the SM Myers Trust book. If there are financial transactions, handle them by using the Doing Business as DBA Lawndale Direct. The management trust can assign a specific DBA to use for transactions of an asset holding trust, or can use a DBA for specific transaction types. Should there be a dispute about ownership, theft of any of the equipment, or other complication involving legalities, this trust becomes key to proving ownership, and should accounting be needed, using the DBA can simplify reports. Okay. Come on. Okay, so here's the management agreement. So you got the client is SM Myers Trust. Then you got the management organization as Allen J. Family Trust, DBA Lawndale Direct, number 84, blah, blah, blah. Okay, witnessed. Whereas the client is in the business of rental, maintenance, and repair of precision machine equipment, the client wishes to delegate business. Wait, the client. Okay, let me do that. The client wishes to delegate business administration, whereas the management organization is in the business of providing trust administration management services for Allen J. Family Trust, and is willing to provide such services for the client on the terms and conditions from now on set forth. Therefore, in consideration of the foregoing and in consideration of the agreements hereinafter set forth, the management organization and the client agree as follows. 1. The management organization is responsible to handle the following areas of asset administration. A. Financial. A1, fiduciary duties. 2, payroll or contract payments. 3, banking and investment transactions. 4, lease administration. And 5, collection. Then we've got B, legal. Correspondence, filing with county, state, and federal agencies. Then you've got 3 is consultation with legal experts, paralegals, trust consultants, lawyers. Next one's 4, research. You got 5, transactions. Under transactions, you got leases, rentals, mortgages, deeds, and titles. Then next one is C, tax matters and dealings with tax authorities. Under that, you got payroll taxes, state and local taxes, and federal taxes. D, application, pass-through accounting, and disbursement methods and procedures. E is control investments to benefit the larger trust group known as Allen J. Family Trust. F, trust administration, including but not limited to 1, Board of Trustees meetings. Under that, you got location and agenda. 2, hiring and training of trustees. 3, hiring, training, and ending of service of administrative personnel. Then the next one is asset administration includes A, inventory, buying and selling of assets, repairs and equipment maintenance, insurance. Next one, 3, is length of contract, 10 years from the date as shown below. 4, duration and termination for good cause such as death, sale of trust corpus, any emergency or crisis affecting the financial status of the client. Ending of this agreement by either party needs 60 days prior written notice to the other. With writing notice of ending, the management organization will make changes only with the consent of the client. Termination of this agreement does not affect or preclude any transactions started before such termination. Prompt delivery of all properties or described in paragraph 1 to the client, guardian, heirs, executor, or personal representative after termination allows for reasonable delay of recordation of titles, deeds, mortgages, or leases. 5. Powers, acts, and omissions of the management organization. The management organization agrees to undertake and effect transactions for and at the risk of the client in such a manner as the management organization believes advisable without notice and approval by the client. 6. Managing fees. The client pays the management organization a quarterly management fee of not less than 5% of lease payments for equipment held by the SM Meyer Trust. This fee is deductible from disbursements to this trust. 7. Further privacy terms. This agreement protects all the trust business by the common law privacy trust or privacy rights available in every applicable jurisdiction. The penalty for the release of any information with this agreement or any related material, anyone responsible will be fined or made party to a tort action for no less than $100,000. 8. Liability. The management organization may not convert any of the properties held in the trust without unanimous approval of the SM Myers Board of Trustees. The management organization may not be held liable for any actions which it may perform as management organization unless the management organization has been found by a court of competent jurisdiction to have acted outside the scope of the contract, or that it has acted in bad faith in carrying out the duties of this agreement. Lastly, 9 is effective date, assignment, governing law. Sorry, trying to feed the dog. This agreement is binding on acceptance by the management organization, provided though the client may revoke this agreement without penalty within 5 business days after the execution date set forth below. This agreement may not be assigned by either party without the other party's written consent. This agreement sets up a contract entered in and governed by the laws of Ohio, binding on successors and assigners of the parties previously. This agreement made and completed by the management organization and the client, dated September 10, 2004. Okay. Does anyone want to, by any chance, read today?
I'll attempt if you want me to.
I would gladly love you if you did.
Where do you want me to start?
Okay, you're going to go chapter 9, your piece of the action.
Is that page 98, I think?
99.
Yeah. Excuse me. Okay, your piece of the action. There are 2 different certificate classifications: trust capital units, CTUs, and units of beneficial interest, UBIs. Often confused and used interchangeably, both in law and in different trust types, we take the opportunity to clarify their separate uses. Through our experience with exchange processes and many beneficiary issues, we share with you the evolution. This is how both certificates can work together. Because a private trust can be designed by the grantor, the way to use the certificates are up to him or her. By sharing our experience, we present some of the possibilities. The difference between capital and beneficial interest. The certificate process is the dividing line between an irrevocable common law trust and an irrevocable statutory trust. Only trust capital units are found on both the management trust and the business trust. For the asset holding trusts, both trust capital units and units of beneficial interest apply. We feel that unless beneficiaries expressed an interest in the trust, or demonstrate maturity, they should probably hold UBIs instead of TCUs. By the management or business trust given the asset holding trusts, TCUs, they become beneficiaries and pass the distribution onto the holders of UBI. We just need to process that as something. Okay. Also, you may put a friend on as a UBI holder instead of as a TCU holder. Further, the grantor can specify that only direct descendants can hold TCUs and that TCUs cannot, I think that means be assigned to those outside the family, while the UBIs may be more broadly applied. The name tells all. Capital is equivalent to corpus, and interest is equivalent to profit. The corpus becomes the principal and generates the profit. Cash out of the principal, the working capital, and the profits cease. Okay, cash out the principal, the working capital, and profits cease. So the certificate holders of the trust capital unit will interest in the part of the corpus if and when it is dissolved, or if the distribution of corpus is decided by the Board of Trustees. The UBI holders only receive funds only when there is a profit. Cash out the principal and the profits cease. In this case, the certificate holders of the UBIs will get a lesser distribution or none at all. Dissolving corpus. For example, the corpus of an asset holding trust is residential property. When the home is sold, the corpus is liquidated. The management trust is the trustee, usually holding up to 51% of the TCUs. The remaining 49% can be distributed or reinvested for the TCU holders on the asset holding trust. The majority of funds pass through to management trust, where funds gained from the sale can be put into a stock portfolio to generate a cash flow for the management trust TCU holders. If there is a profit on the sale of the home because the real estate market increased over time, then the Board of Trustees can distribute the corpus plus the profit to the trust capital certificate holders. The asset holding trust, as a TCU holder in the management trust, receives part of the corpus and part of the profit. From this, it makes a distribution to the certificate holders of UBIs. If an interest-bearing account produces a cash flow of $2,000 a month, the TCU holders get their cut, and there is a trickle down to the UBI holders. Cash out the principal and interest ceases. This will become clearer when we review the trust certificate registers in the next chapter. Exchanges and transfers. As mentioned.
Hold on. So, not agenda. Appendix K, format 44.
Mm-hmm.
So that is okay. So K covers, I'm just going to read the registers and certificates. Volume 1 mentions the Lewis Chase Pazer Trust. At one time, probably one of the largest trusts in the world. It owned a long list of impressive assets. Because of its size, it came under investigation of Congress. Hidden TCUs. The information about the trust came to light through the current day heirs discovering the TCUs in a vault. These financial instruments proved their claim on the trust assets. A long investigation evolved the facts as outlined in Volume 1. This trust became subject to plunder by some of the biggest names in the history of the financial world. Here again, we see when the trust is not administered for the beneficiaries, the focus dissipates. The finances of this trust have been long in disarray, and whether the heirs will ever see the funds was a subject of debate when Chapter 10 was first published. Right of distribution. Note, though, that holding TCUs proved their right to the beneficial disbursement because TCUs are financial instruments, and when you get them, keep them safe. The trust is likely to show under good management, and if you want it to grow, you may want to participate in that management. So sample format 44 is Trust Capital Unit Register. The story about this Trust Capital Unit Register is given in Chapter 10. Since there was not enough space to include all of the columns, we deleted the last one titled Trustees Authorization. Because of the seriousness of financial allocation, it is best to have the trustees initial or draw a diagonal line across several of them, and one of the trustees can sign his or her name to cover many names. Our experience is that the Trust Capital Unit Register is an active trust. In an active trust needs to be updated or reviewed at least twice a year. So this is what it looks like. All right, so you got the issue date. So this is for Trust Capital Unit Certificate Register of the Sherman M. Patterson Family Trust. January 10th, 2006, you got the issue date, you got the name holder, you got the quantity, certificate number, date of transfer or notations, amount returned, active TCUs, and total assigned. So let me see all of these. Date of transfer. So this Courtney, general manager, her TCUs were transferred on May 16th. Amount returned. So I guess she cashed in 5 of them. So now she only has 255. So this is kind of what it looks like. Active TCUs. Yeah, I can see why you would need, I mean, you're talking about 436 total assigned. I can see why this is very important. Okay. So go ahead and continue. I'll read the appendix and then you just read the chapter. For 9, that is.
Okay, do you want me to continue, or are you still in the appendix?
That was it.
That was it? Okay. Exchanges and transfers. As mentioned previously, there are no certificates for assets exchanged into the irrevocable statutory trust. When people put assets into a statutory trust, they often pay a gift tax. In a corporation, assets can be exchanged for shares. When those shares are cashed out, the tax is due. It is the exact same with TCUs in an irrevocable common law trust. When the TCUs are cashed out, the tax is due. If you are an exchanger, the paperwork you received when you placed your assets into the trust will state the asset value. When you cash out your certificate, the difference between the original value and the current value is the amount to report. Units of beneficial interest do not require an exchange and may or may not have a cash out value. This depends on the circumstances stated in the indenture and what the Board of Trustees decides. Not tradable. If you hold a certificate for 100 TCUs, the only buyer is the Board of Trustees. You cannot trade your share to your brother or sister, nor can you give certificates to your children. You can return them to the Board of Trustees, which may or may not reissue them according to your wishes, or you can sell them back to the Board of Trustees should there be sufficient cash flow in the trust and the Board of Trustees and you agree on the value. This is a valuable option if you need funds more than you need your vested interest. Units allocated incorrectly. Proper unit allocation and implementation of the exchange process are presently not well understood. This is because the knowledge of how you set up a trust properly has been lost. In most of the common law trusts, TCUs have been allocated incorrectly. In both Chapter 11 about scam trusts and Chapter 12 explaining the common formula of when a grantor is taxable, it is easy to see how mishandled certificates have been. It is a most basic error. Expertise and dedication. The administration of the certificate register requires expertise and dedication. It has often been our experience that many people who become trustees are not aware of the time and commitment needed to learn the more subtle intricacies of the common law trust distribution system. Training materials are not readily available to the general public, and so the application of shared wealth within a trust seems foreign. Before we take you into the details of a trust certificate register and how it all works, we first will explore legalities about these certificates, as many lawyers do not believe the exchange process is legitimate. Thumbs down to gift taxes. We examined the writings of one of the leading authorities on the subject of the irrevocable statutory trust, looking for a better understanding of certificates. The irrevocable statutory trust seems more designed to gain tax advantages, but has no information about exchanges or certificates. Mr. Turner's work is impressive, and anyone needing assistance with setting up an irrevocable statutory trust should consult with him or those who are of his ilk. In a dialogue with the law firm about this subject, the idea of trust certificates was deemed illegal. They focused on payment of a gift tax. So we asked one of our legal researchers to delve into tax law to clarify the legal position of asset exchanges for certificates and how and when a gift tax is applied to this situation. We found some noteworthy data. Apparently, the entire idea of exchanging goods into either a trust or a corporation is not so unusual. There are court cases where this issue has been decided and where even large amounts of money have been discussed to the penny. The law firm which queried, is that how you say that? Queried?
Queried, I think.
Queried? Yeah, that makes sense. Thank you. The law firm which queried us stated that a gift tax is due at the point where the goods were placed into the trust. We share with you the following words from authorities who ponder these tax items and who also disagree with the law firm's opinion. We first establish the point of value. It is at the time the asset is put into the trust. Fair market value for the purpose of the Internal Revenue Law is the price at which a seller is willing to sell at a fair market and a buyer is willing to buy at a fair price, both having reasonable knowledge of the facts in the trade. On the grantor's side, the trust certificates received for goods placed into a trust have no reportable or determinable value to be declared. Continuing with the American National Bank case. Property received in exchange for other property has no fair market value. For the purpose of determining gain or loss resulting from such exchange, when owing to the condition of the market, there can be no reasonable expectation that the owner of the property, though wishing to sell, and any person wishing to buy will agree upon a price at which to trade unless one or the other is under some peculiar compulsion. When the trust certificates are cashed out is when the value is ascertained. The IRC recognizes, is that the Internal Revenue? What is IRC?
Good question.
Sorry, need to know what I'm reading.
What's that, Judy?
Internal Revenue Code.
Oh, thank you, Judy. Okay, the Internal Revenue Code recognizes that a taxable status exists when transferred into the trust organization, but any tax payment is deferred until distribution from the trust organization to the beneficiaries. In the American National Bank case, the judge rendered his opinion as follows. It is my conclusion, therefore, that the assets received by the trustees held no determinable market value when they were received in 1936, and no determinable market value at any particular period subsequent thereto prior to 1944, and that the plaintiff was entitled to take credit in 1944 as a capital loss. The difference between $22,100, the cost of its stock, and the sum of $7,870.26 received by it as a result of the liquidation of the exchange assets is so ordered. To further our legal research, we took a hard look at an often quoted case, Burnett versus Logan. No tax is assessed on the conveyance of property to a corporation or a trust because the exchange constitutes a tax-free trade in exchange for an unknown realized gain or loss. Trust certificates which have only a contingent future interest of indeterminable value are not taxable. The tax is not evaded or avoided, it is merely deferred. A promise to pay indeterminate sums of money is not necessarily taxable income. Generally speaking, the income tax law is concerned only with realized losses as with realized gain. From her mother's estate, Mrs. Logan obtained the right to share in possible proceeds of a contract thereafter to pay indefinite sums. The statute definitely exempts bequests from receipts which go to make up taxable income. Note to be deterred from our search, we found more. A voluntary contribution by a taxpayer to a corporation or a trust of which he is the sole owner held not a gift subject to gift tax. Okay, we feel these court cases references might satisfy those who have wondered about the finer points of the tax benefits inherent in the creation of an irrevocable trust. We must warn you, though, once items are placed into a trust, removing them can create exceptionally aggressive tax consequences. This, of course, is the reason the irrevocable common law trust is perpetuated. When you can use the asset without either the tax consequences or the responsibility, why take it out of the trust? This also encourages trustees to keep the assets together and to make the trust grow. The option to cash out assets always exists. Do not expect the trust to always make a profit. Sometimes it is necessary to cash out corpus to make it to the next round of good luck, or to make the magic of asset multiplication happen again. In the common law trust, though, the beneficiaries can use the physical assets as in home, cars, furniture, without tax consequences. Cash distribution is taxable to the beneficiaries, but the beneficiaries protect the assets by receiving the distribution and paying the taxes. How so, you ask? When the 1041 tax return is filed and no K-1 distribution is reported, no matter how small, the IRS quickly recognizes a fraudulent trust. This sends up a red flag. The irrevocable trust is a pass-through accounting system. Choose your counselors wisely, for in this matter, a mentor is needed. We hope you are ready for the next leg of your journey. We have designed the following chapter in story format to make a complex matter as simple as possible. All right, I have a question because I am totally on this. So,
Yes.
okay, so let's say like on the prior page where they said they put was it a stock for 22,100? Yeah, it was the cost of the stock, and the sum of 7,870.26 received by it as a result of the liquidation of the exchanged asset. So which part is taxed? It doesn't actually show the loss, right? Because it was put into the corpus and they don't recognize the amount at that point for tax purposes. But is the $7,870.26 taxed? That is a little confusing to me.
Okay, let me reread it. Therefore, that the assets received by the trustees held no determinable market value when they were received in 36, and no determinable market value at any particular period subsequent thereto prior to 1944, and that the plaintiff was entitled to take credit in 1944 as a capital loss. The difference between the 22,100 cost of the stock and the sum of the 7,800 received by it as a result of the liquidation of the exchanged assets.
Who took the loss?
It seems as though isn't this saying that they paid $22,000 for the stock,
right,
and there's no money being made between 36 and 44. And so when they liquidated that stock, it only came out to be 7,800.
Right, which created a loss.
Right. So that's why when they did the tax, they did a loss. And the IRS is saying, well, wait a second. They paid $22,000, so they should be paying the tax on the $22,000. And they're like, no, because when they liquidated it, it only came out to 7,800, which was a huge loss. So they don't pay any taxes on that.
But this is where my confusion lies. Who's paying it? Is that 78 to the beneficiaries?
Yeah, because I believe, yes, because when the trust liquidated it, they paid it out to the beneficiaries. And now the IRS is saying, well, they owe us for that liquidation. They owe us for that money that they received. And they're like, no, because it was a loss.
Well, right. And okay. And then it's saying that on the next page, when they file a 1041 tax return and there's no K1 distribution reported, no matter how small, the IRS quickly recognizes a fraudulent trust. But they revoke the pass-through accounting system. Yes, so that's a little confusing to me also. So if they're doing a 1041, who's filing a 1041? Is that the trust?
No, that would be the beneficiaries. The trust. Well, this is where I'm confused too, because I'm like, well, when does the trust ever have to pay any taxes unless it liquidates something? And maybe if it liquidates, say they have a property and they sold the property that was in the trust to make some cash flow, but they put that cash flow in a bank account. They didn't give it to anybody. Then I think the trust will need to pay taxes at that point. But
isn't it in the bylaws though? Doesn't the grantor or the settlers, don't they make the laws whether the trust is going to pay the taxes or the beneficiaries?
Well, it's my understanding that the whole reason for giving beneficiaries money from the trust is to lower the tax bracket. So that way, because if you take like $100,000, let's just say $500,000 or something like that, they make on like a really small piece of property that they sold. So instead of, because that is a positive influx of money, the trust will have to pay the taxes on that. So to bring them into a lower tax bracket, what they do is they give that money to the beneficiaries who are in a much lower tax bracket to keep the trust from getting taxed at a high rate. However, I'm getting a Charlie horse right now. Oh God, this sucks.
Girl, potassium.
I know, super low. And no matter how I move my foot, it just freaking kills. But I think because of a loss, you don't necessarily, you're not having to pay anyone because it was a loss, because the trust put money like the $22,000 as a money, and then, or $22,000. Now, had the stock increased to say $50,000 and then they did a tax distribution, I think the IRS definitely could have come after them. But because it was a serious loss, then no tax could be taken. They can write it off as a loss, per se.
Well, okay. So I just looked up to see what a 1041 tax return is, and that is a tax return for estates and trusts. So here they're saying when it was filed and there was no K1, because a K1 would go for the beneficiaries, right? If I'm not mistaken, if I understand my accounting correctly. They're saying that, hang on, the irrevocable trust is a pass-through account. Choose your accounts. So I'm assuming that they didn't pay taxes on it, because they're saying, well, maybe they did take the loss as the trust in a 1041 return.
Yeah, maybe it wasn't the beneficiaries, but
no, it wasn't the beneficiaries, because a K1 is what a beneficiary gets when there's a distribution through a trust. I'm pretty sure. We have to have room. She has some distributions. I'm pretty sure that's a K1. Like if a partnership, anything like that, the distribution at the end of the year, you get a K1. So they're saying it was filed without a K1. So the 1041 tax return is for a trust or an estate. So they filed it at a loss, I think.
Yeah, so K1 is the form that reports the amounts that are passed through to each party that has an interest in an entity. Okay, so
it must be the trustees too, then maybe.
Yeah, well,
Howard, we need to ask
Howard.
It
has to be passed through to another party.
Right, but they said they didn't file a K1. There was no pass-through.
Schedule K1 is a federal tax document used to report the income, losses, and dividends for business partners, S corps, shareholders, and investors in limited partnerships and certain ETFs.
It just says losses, no gains?
It says income, losses, and dividends.
Sorry.
So, yeah, so I guess even if you have a loss, if you don't file that K1, it's going to be a red flag to the IRS.
And then is this saying at the end on 104, when they filed it and there was no one there was no K1 distribution reported, they
Yep.
did, it was fraudulent?
Well,
Because-
the IRS recognizes it as it puts up a red flag for the IRS to go after that trust because
Okay.
something fishy's going on.
Okay.
So even if you have a loss, you still need to report it. But if you're submitting a 1040 without the K1, then that's an immediate red flag.
So I wonder how that works if you're reporting the loss as a trust. That's interesting. Okay. It's just a thought. Okay, that makes sense to me.
All right. Anybody else have questions about what she just read in chapter 9? Okay. Does anybody else want to take a shot at chapter 10? If not, I'll read it. Okay, I take that as I'll read
Actually,
it.
question, if I could. I'm sorry.
Yeah, no, go for it.
I'm sorry, I overtalked whoever that was. Okay, so I'm getting the impression that the trustees are really in a great position because they own those certificates, those trust certificates versus the beneficiaries. Did you any that impression here?
Well, I mean, again, ownership's great, but with ownership comes liability too.
Right, but those TCUs, I think, are those trust certificates. I never even heard of them until I read this book. And you know how you always hear of trust, but anyway, I just thought that entered my mind. Okay.
Let's see who did that. Well, let's continue reading because the next chapter talks about mysterious TCUs. All right. Although we focus on the management trust and its certificate registration, you may want to refer to Chapter 4 on trust structuring to refresh your understanding of the trust layout. Register tells all. For now, we focus only on the trust capital unit certificates. The certificates reflect units given in exchange for assets or given to officers and beneficiaries who have not joined in the exchange transactions. The TCU register is complex, and the more changes in the trust group, the more sophisticated the trust certificate register becomes. Refer to Appendix K, sample format 44, which we just went over, which was showing like people having 400 and 500 frickin' certificates. So follow this register to see the transactions over the years. Note how funds added to the trust affect distribution to the trust certificate holders, as well as the various uses of TCUs. To make this easier to understand, we dramatize the story of the register to make the people and entities involved seem more real. Within this group, you see how and why TCUs become inactive and active, and how beneficial distribution happens. Just want to make sure. We did do K44, right? It wasn't 45. Yeah, it was 44. Okay. The grantor. On October 10, 2001, Terrence A. Wilson, as grantor, set up the Sherman M. Patterson Family Trust. In his late 40s, this well-traveled, red-haired, energetic man had a rounded education, keenly interested in preserving assets for his family to avoid probate and to minimize taxes. He put some of his wealth into the Sherman M. Patterson Family Trust. He previously set up other modules or modalities to protect his family, including 2 other trusts for his children. With an available 500 TCUs in the Patterson Trust, Mr. Wilson received 1% of them. 5 for starting this asset preservation arrangement. In addition, he placed $100,000 cash plus rental income and a stock portfolio into the trust, and thus became an exchanger. Although the rental income is assigned to the trust, the rental property is a separate asset holding trust. This initial funding sets up the corpus to produce the cash flow and becomes the accounting baseline for the trust. Mr. Wilson receives certificate number 001 and 002, giving him 65 TCUs for his contribution to the Sherman M. Patterson Family Trust. Because he put funds and other assets into the trust, trust certificate number 001 and 002 are active. They are identified by the words grantor and exchanger after his name, as opposed to identifying TCUs given to trust officers, which I'm assuming would be the trustees, the general manager, all those people. TCUs receive payout per the percentage they represent when the trust makes a profit. The first trustee, Mr. Frank C. Ellis, an elderly gentleman with white, wavy hair and a gentle disposition, became the first trustee. For this, he received 125 TCUs, establishing him with vested interest and satisfying the IRS Title 672, where the adverse trustee must have a greater interest in the trust than the grantor to qualify the Sherman M. Patterson Trust as an irrevocable trust. If Mr. Ellis had fewer TCUs than Mr. Wilson, this would be a revocable trust, and Mr. Wilson would hold more control than Mr. Ellis, thus having the authority to fire him. Okay. If the energetic grantor kept that power, he would also be responsible for the income tax of the trust. Mr. Wilson asks Mr. Ellis to become the first trustee. Mr. Ellis only agreed if he could add a family member as a beneficiary. Mr. Wilson agreed if the person selected became a holder of units of beneficial interest instead of a TCU holder. They agreed on 10 UBIs for Mr. Ellis's granddaughter. She would belong to the asset holding trust Terran Blue. Mr. Ellis, as first trustee, becomes responsible to hire all other trustees who join the trust after him. The grantor, Mr. Wilson, now has no authority to hire or fire any other members of the trust group. The elderly trustee is also obligated to take the cash flow created by this beginning contribution and multiply it for the beneficiaries. If Mr. Ellis is not skilled in this task, then he may choose to consult with professionals or rely on other trustees who have the expertise. Active and inactive TCUs. At the time the trust became settled, the mild-mannered first trustee did not put any funds into the trust. His certificate number 003 for 125 TCUs remained inactive. That is, he only receives a payout if the original corpus or a portion of it is cashed out and the trust dissolved. Recall, the initial corpus consists of $100,000, rental income, and stock portfolio. This means if the stock portfolio is sold, the funds are put into a checking account. This cash is distributed to the trust capital unit holders instead of reinvested into other avenues to produce an increase to the trust. There are only a couple of reasons to do this, not covered here. Note, though, it is not a likely event since obviously Mr. Ellis, who as trustee holds a greater percentage of TCUs than the grantor, would receive more funds than Mr. Wilson. Wait, no, though it is not likely event, since obviously Mr. Ellis, who is a trustee, holds a greater percentage of TCUs than the grantor, would receive more funds. Huh? Oh, okay. Obviously, Mr. Randall would receive more funds than Mr. Willis. Okay. If the stock portfolio continues to provide a cash flow, it contributes to the overall profit. Mr. Ellis receives a distribution for his 125 units, representing 25% of profit, if he has activated them by putting his own funds into the trust. Although a trustee can have 51% of the interest in a trust, in this case, because there are other members of the Board of Trustees, the 51%, 251 TCUs, is shared among other trust officers. The beneficiary. Without a bona fide beneficiary, there is no trust. Mr. Wilson named Terran Blue Trust to receive a beneficial distribution. The Terran Blue Trust, named after a vacation spot, is where the Wilson family often visited when the children were growing up. This trust's beneficiaries are two of Mr. Wilson's children and Mr. Ellis's granddaughter. Terran Blue Trust, by virtue of holding the TCUs in the management trust, Sherman M. Patterson Family Trust, receives a distribution and passes it through to the UBI holders. Okay, activation of officer TCUs. As time passed, the Board of Trustees decided to activate one trust capital unit per year of service for all board members, also referred to as trust officers, whether or not they added funds to the trust. In this particular case, the Board of Trustees, in consultation with the grantor, realized that without the trustees performing their duties, the benefits of asset protection and tax advantages would not apply, nor would the assets multiply. Whether or not the trustees contributed financially, they added to the value of the trust. The merit of the fiduciary becomes more obvious as time passes. Although soft-spoken trustee Ellis receives at year-end 2% of beneficial distribution, this new bonus gives him an even greater incentive. As the cash flow increases, so does his percentage. The trustees may receive an hourly remuneration. I hate these words sometimes, to supplement their compensation, depending on the cash flow of the trust. They can also have active TCUs. Further, Mr. Ellis, as well as the other trustees, became more valuable as events occurred, which they handled. They studied legal cases involving trusts and grew more aware of proper accounting procedures and protocols. Having performed dutifully for the beneficiaries, activating one trust capital unit per year for these trustees was an obvious decision. Fiduciary fees. 3 years from the time the decision to activate the TCUs occurred, Mr. Ellis received 3 active TCUs. For example, if the initial corpus produced $7,000 a month to the Sherman M. Patterson Family Trust and all 500 TCUs are assigned, then each unit becomes valued at $168. So Mr. Ellis received $504 a month, but as time passes and assets multiply, this can roll into a much larger sum. 63. So 7,000 times 12 months, 500 TCUs equals $168 each unit times 3 units equals $504 per month. The Board of Trustees or the grantor has discretion about how much of the profit goes to distribution. Although $168 per unit could be shared, it may be it may be valued less to use funds for other projects. Because the initial funding of the trust did not produce a large trustee year-end percentage, Mr. Ellis and other trustees charged an hourly rate. As the trust amassed more funds, thus increasing the year-end percentage distribution, the hourly rate decreased. The second trustee. Following careful screening, the first trustee hired Chris L. Heff, a young, stout paralegal with a sunny disposition and thick glasses, as the second trustee. Because he had much experience than the senior trustee, he received 50 TCUs. They were initially inactive. He served for 3 years, learned the intricate accounting procedures, and received 3 active TCUs. At the end of every year, he also receives 1% of financial distribution. The protector and general manager. The trust protector, Muriel J. Allen, a business consultant with long, dark, curly hair, received 1% of the TCUs, and Courtney S. Brown, an overactive salesman, became the general manager and received 1% of the TCUs. It was uncertain how long he would be able to serve and how much time he could commit. He resigned 3 years later, returning his 5 TCUs shown on certificate number 006 to the Board of Trustees. In that time, he helped set up a partnership, adding $4,000 a month to the cash flow. The executive secretary. Miss Anita L. Willen, the executive secretary, received trust certificate number 007 for 30 TCUs in March of 2002. These were inactive. Involved with paperwork and management details, she spent more time than others on trust work. She realized the potential of the various investments of the trust and saw the assets grow. 3 years later, she became an exchanger, adding funds to the corpus of the trust. She received another certificate number, 014. Being a member of the Board of Trustees, she also received 3 active TCUs of her original certificate number, 007. More exchangers. The Wilson Amber Trust, set up by the grantor's wife for their children in 1980, added $5,000 to the initial corpus for 4 TCUs. The Blue Crystal Management Company, owned by Mr. Wilson's father, became an exchanger for 5 TCUs when it added another $30,000 to the corpus. The inconsistency of how many TCUs given is per negotiation with the Board of Trustees. Timing and value are other reasons. Successor trustee and grandson. Mr. James E. Hughes, a grandson attending college, became a successor trustee for 50 TCUs in May of 2004, but remained only until September 24, 2004. He then surrendered 25 TCUs to the Board of Trustees when he left the area to follow a medical career. For his service to the trust, because he was a direct descendant of Mr. Wilson, and became the trustee training experience, and because the trustee training experience he received while helping the Board of Trustees will serve the family well. He kept 25 inactive TCUs. Note that later a split occurs and a symbol is made on the register. The 25 TCUs are not to be confused with those activated yearly for the other trust officers. At this point, none of these 25 is activated. Third trustee. Because of his real estate background, Thomas J. Holden became another trustee September 22, 2004, and received 50 TCUs. With the increased cash flow from cash-producing investments, this new trustee bought both vacant land for speculation and an apartment building to add to the growing cash basis. The apartment building was transferred into an asset holding trust managed by the Sherman M. Patterson Family Trust, while the rental payments from the apartment units came directly to the trust. The young paralegal trustee handled the accounting. After 1 year, Mr. Holden received 1 active TCU. Training the teenager. Jennifer Stunner, the 15-year-old niece of Mr. Wilson, became successor trustee in training on February 8, 2005, for 10 TCUs and aided the Board of Trustees with various facets of trust management. As a diligent student interested in the family profits, her newly acquired trust business knowledge ensured a future for the trust group. Alto Management, a business of Jennifer's father, added more money into the trust coffers in May of 2005 and received TCUs, as shown on the trust certificate register. Note, successor trustees have no signature or other authority until they become trustees. The new beneficiary. In 2005, the Board of Trustees gave to Mr. Wilson's first grandson 20 TCUs. Splitting TCUs at this point. The original 500 TCUs were nearly all assigned. The board members voted to do a 3-to-1 split, yet the current TCU holders would get only a 2-to-1 split. This gave enough extra TCUs unassigned to allow for the continued growth of the trust. When certificate number 011 is split 2-to-1, the 25 active TCUs appear in the quantity column, and a note about number 011 with number 027 appears. Family involvement. The living trust and other statutory trusts do not have TCUs. As you can see, this extra feature plays a key role in trust management flexibility and distribution. The family can become more involved with the growth of the trust. The ownership of the assets remains with the Board of Trustees. The vested interest in developing a future for prosperity and shared revenue becomes a matter of expanding fascination, especially when those checks keep coming to the beneficiaries. Transfers and exchanges. The TCUs given for assets exchanged into the trust happen through paperwork created by the exchanger to transfer legal title to the Board of Trustees. Okay, we have Appendix B. All right, under Appendix B, page 341, says loading the trust. This section applies to both irrevocable and statutory trusts. The funds initially put into the trust fix the baseline of the trust value. This is the starting point, known as original corpus. When put into financial instruments under the trust name, corpus is referred to as principal. From this point, the settlor decides whether income is applied to corpus or profit. Trust value. In our Allen J. Family Trust Sample Format 6, the first funding totals nearly $800,000. As the years pass, the value of the trust varies in reference to this number. When the trust value falls below $800,000, all income-producing funds are first applied to principal, then to income. Long-term or short-term capital gains are based on the original corpus at the time of its sale. In a trust, this baseline value is where the grantor's retained power to decide corpus and income begins. Okay. Crap. Hold on, guys. Okay. Bum, 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 bum. Wait, dadgummit. Sorry. All right, back to chapter 10. The exchanger then receives a certificate. The Board of Trustees settles the number of TCUs through negotiation with the exchanger. The certificate gives the right to receive distribution and is a financial instrument. Any other rights determined by the grantor stem from the trust indenture. Each indenture is unique to the grantor's wishes. This is why, quote, boilerplate, unquote, documents for a trust usually are not enough to handle the individual needs of a family. Beneficiaries are serious business. The exchanger, the one who puts assets into a trust, always names the beneficiaries. Besides gaining the benefits of asset protection, the real reason to place funds in a trust is to care for the beneficiaries, who may be a spouse, children, aunts, uncles, and nephews. They also may not even be related, because the irrevocable common law trust is a private contract. Even friends can be listed as beneficiaries. Because of the serious nature of naming beneficiaries, they are not easily removed. This is not the place where you play musical chairs. Named beneficiaries are part of the group. The Board of Trustees intends to keep them as beneficiaries. Trust certificate holders are beneficiaries whether or not the units are active. This fact will help you to understand several court cases where trustees are referred to as beneficiaries. In reality, they are the only beneficiaries. Under the trust contract indenture with the grantor, they agree to distribute funds to the people named by the grantor. The word indenture means, quote, a contract binding a person to work for another during a given time, unquote. And that definition is from Webster's New World Dictionary of the American Language. Pooled resource management. As the trust invests and perhaps sells acquired residential property, the profits can be returned to the pooled funds to produce a greater cash flow. A portion or all the profit made will be distributed to the grantor and the other trust certificate holders who have active units. The certificate holders do not need to accept the funds. They can assign them to others. For example, the grantor does not wish to receive funds from the trust. He or she can redirect the payout to another trust member by writing the Board of Trustees. Further, the distribution can be reinvested. Corporation's assets and shares. A corporation can give a person shares of stock for assets given to it. We know of one case where a grand piano was exchanged into a corporation for shares. The piano was tagged as being the property of the corporation and housed in the home of a corporate officer. When an IRS agent came by planning to confiscate the piano, the corporate tag prevented the agent from taking it, as it did not belong to this corporate officer, but to the corporation. The corporate shares allow the holders to vote about corporate decisions. This is known as having voting rights and sets up ownership. Any funds the corporation makes become a tax liability to the shareholders, who also pay tax on any dividends they receive, double taxation. Contrary to this, the TCUs given to someone who has exchanged assets into the trust have no voting rights. That is, the trustees now own legally whatever is in the trust. The person holding the TCUs has no say about the disposition of the assets unless the grantor holds the power within the trust indenture. When there is a distribution, there is no double tax. Anybody have any questions so far? Okay. Buying the trustee position. In larger trusts, it is proper for a trustee to buy his position and thus seriously invest in the trust when becoming a trustee. In this particular case, the trustee may get 2-for-1 TCUs for personal money invested, may need to buy the TCUs at their current price, or may elect to waive annual fee and apply same to TCU activation. The object here is to ensure the trustee has enough motive and holds major vested interest, not the grantor. Not wishing responsibility for the taxes or liability for lawsuits, and to ensure the future of his family, this works to the grantor's advantage. With beneficiaries, it is more suitable to offer incentives for them to become more active in the trust, or for them to make certain achievements in their lives before giving them extra UBIs or TCUs. Consistent changes. As the trust grows, there are many changes that occur naturally. Through marriage, the female beneficiary often changes her surname. This requires the original units to be returned to the trust and reissued under her new under her new name. Adding children to the trust often means more units issued. As stated earlier, trustees may also come and go. Certificates may be lost. As mentioned earlier, there may be those officers and trustees of the organization who decide to activate their TCUs. As shown, there are also times when a split occurs, creating a 2-for-1 or greater split. Distributions. By using the equity in the trust, a rough estimate of the TCU value settles a starting point for exchange negotiations or to cash out the TCUs. The grantor may decide the distribution unit of the TCUs if that power has been kept without affecting his non-ownership status. That's IRC Title 674B, the power to distribute, appropriation, or accumulate income to or for a beneficiary or beneficiaries. The grantor may also hold the power. The grantor may have also held the power to decide corpus and income to build up the assets in the trust. That is IRC Title 674B8, power to allocate between corpus and income. Where the grantor has a power to allocate receipts and disbursements as between corpus and income, even though expressed in broad language. The board of trustees or the grantor controls the percentage and the frequency of the payout. The objective of the irrevocable common law trust is to pay zero taxes, so the beneficiaries pay the tax. Please note, the beneficiaries only pay tax if they are subject to the U.S. tax laws. I think that's a hint there. They may not be subject because they are either beneficiaries in a foreign country, like the Republic country, or they are charitable organizations. Beneficiaries in foreign countries who are not U.S. citizens fill out a 1040 NR, non-resident alien, after receipt of the K-1. Good to know. Ignorance and the red flag. Banks and the IRS cannot differentiate between one trust type and another. As documents submitted to financial institutions generally do not identify the nature of the trust, unless paperwork submitted describes a trust as an irrevocable common law trust, then it appears to be just like any other kind of trust. An improperly administered trust becomes identified by how people fill out their personal tax return information and how the trust paperwork is submitted to the IRS. If the paperwork is filled out correctly, it appears the same as any statutory trust and thus transparent. Uneducated in tax processes, those with scam trusts incorrectly fill out the paperwork. Once the IRS suspects the use of a common law trust, they assume most people involved with it have no idea how both the administration and tax laws apply. Chapter 12, about screwball trusts, supplies the details of these mistakes. Failure to file county paperwork correctly for homes in trust also gives a clue that something is amiss. Having the property under the trust name with the grantor as trustee does not work if one claims the trust is irrevocable. If the grantor has a strong enough control of the family, the irrevocable common law trust can be a dynamic tool to share wealth. The status of beneficiaries does not change when the grantor passes. When properly trained, the trustees will have control and provide equitable disbursements. When the grantor is no longer able to contribute, the trustees take full responsibility and assume all activities. The common fears and frequent mental disorders of old age will not threaten the assets, as the trustees continue whether or not the grantor is involved. All right. Anybody have anything they want to bring up regarding that? Because I don't think we're going to have time to start another chapter.
Learned.
What was that?
There is a lot to learn.
Yeah. I still am confused with regards to, so you start out with 500 TCU. Wait, is it certificates? Trust certificate unit. How do you determine a percentage of what somebody's going to get with each TCU? So let me go back to the beginning. Okay, so let's go back to the grantor. So Mr. Wilson, being the grantor of this Sherman M. Patterson Family Trust, so he put all his assets in there to start the trust. And the trust starts out with 500 TCUs. And Mr. Wilson received 1% of them. So that leaves him with 5. For all the corpus that he put in. But what's the difference between a TCU and a certificate number? Because it says he got certificate number 1 and 2, giving him 65 TCUs. I thought a TCU was a certificate. So shouldn't there be certificate 1 through 5? Because it just says he got certificate number 1 and 2, giving him 65 TCUs.
I think they're allowed to, if I'm not mistaken, the Board of Trustees, they're allowed to create more TCUs only within the people that are holding them as the trustees. So maybe somewhere in here they did that. I don't know.
Well, okay, so every trust starts out with 500. And so when the grantor puts in the corpus, he gets 1%, I guess, of that 500, which leaves him with 5 TCUs. But all of a sudden, it says, let's see, this initial funding sets up the corpus to produce the cash flow and becomes the accounting baseline for the trust. Mr. Wilson received certificate 1, 2, giving him 65 TCUs for his contribution. Okay, wait. So confused. So just because he's the grantor, he automatically gets 1% of the 500 TCUs, but then when he placed the corpus in there, he got an additional 60 TCUs, it seems. So now he's got 65 TCUs, but I don't get what this certificate number 1 and number 2 is. Like, obviously it's different than a TCU. A certificate number is different from a TCU, it seems.
I don't think so, because if you look here, they actually did a split, 3-to-1 split. So it says when certificate number 11 is split 2-to-1, the 25 active TCUs appears in the quantity column of a note about, so there's a note that appears that I think indicates that.
Well, this isn't even when it gets to the split yet, because the 500 TCUs haven't even been given yet. They're going through from the very beginning of him putting this trust into being, and just by him creating, says he previously set up other modules to protect, including 2 other trusts for his children. With an available 500, Mr. Wilson received 1% of them, which leaves him with 5 for starting this asset preservation arrangement. In addition, he placed $100,000 plus his rental income plus his stock portfolio into the trust. And now he's got the title of grantor and exchanger. So, and although the rental income is assigned to the trust, the rental property is in a separate asset holding trust. So, okay, the rental property is in another trust, not the family trust. So this initial funding sets up the corpus to, so is certificate number 01 for the family trust and 02 for the asset holding trust? Is that why he gets 2 certificates?
Doesn't he get the first certificate is 1%, if I'm not mistaken, right? He receives 1%. With an available 500 TCUs in the Patterson Trust, Mr. Wilson receives 1% of that.
Leaving him with 5. That's 5. 1% of 500 is 5.
Okay, for starting this preservation arrangement. In addition, he places the money, the rental income, into the trust, and thus became an exchanger. Although the rental income is assigned to the trust, the rental
Now he's a grantor and exchanger.
it's a separate asset holding trust. It says it right there. Right? Because that's a separate trust now. Yep, I think you're right.
Yeah. So maybe that's why he's got two certificate numbers.
We need to talk to Howard. Gee.
Yeah, I think I think a good question for him is, can you break, like, is it a normal thing? Like when you open a trust, you automatically have 500 TCUs. And so like, and then when you fulfill that 500, all the TCUs are gone. That's when you start doing the split. And so, yeah. Okay. Yeah. See, ooh. Okay. So yes, certificate 01 is for the Patterson Trust. Certificate 02 is for a separate asset holding trust. So now the first TCU was 5 TCUs, which I'm assuming went under certificate number 1. And then the second asset holding trust, maybe he got 60 in those, because you go down to the first trustee, Mr. Ellis, he only got certificate number 03. And that certificate has 125 TCUs. And he had to get more than Mr. Wilson because the trustee had to have a greater advantage over the grantor with regards to TCUs to make him an adverse trustee. So that way he had more power to make changes to the trust and everything than Mr. Willis.
Yeah, but I think, Dawn, and I could be wrong, if you look, they said they are identified by the words grantor and exchanger. So I think he's wearing 2 different hats here, because as the grantor, he cannot have more TCUs, but he is also an exchanger.
Yeah, but he still can't have more than the trustee.
Right, but I'm saying I think there's more to it than we see here, because he's wearing 2 different, like a certificate 1, I think, is the grantor, certificate 2 is the exchanger.
Right.
They added more to it. But now I'm wondering, as the grantor, he's not allowed to have more of the TCUs. But is that the same as an exchanger? Because they're 2 different.
Exchanger is not as high of a title as trustee.
Well, I think it just means he's putting more, he's buying into the corpus. Because anybody can be an exchanger.
Grantor will fund the trust, but
right, and exchanger buys into it, doesn't it?
Right. So here, I think he put $100,000 of cash. So I'm wondering, as an exchanger, although the income. Okay, so the cash in the stock portfolio, that I think went into the family trust. The rental income, because the property says, although the rental income is assigned to the trust, the rental property is in a separate asset holding trust. So it's in a trust underneath the family trust.
So he would hold the TCUs in a different trust.
Yeah, which is where the certificate 1 and certificate 2 come into play. but
And so
he
that would
still
keep
only
you,
has 65 TCUs.
right,
And
keeps you
it
going.
says that Mr. Ellis, the trustee, the first trustee, he received 125, establishing him with vested interest to satisfy the IRS code, where the adverse trustee must have a greater interest in the trust than the grantor to qualify the Patterson trust as an irrevocable trust. Because if Mr. Wilson gave himself more than Mr. Ellis, then it would not be an irrevocable trust. It would be a revocable.
And then he would be in charge of the income tax.
Yes.
Okay. That makes sense.
And then it says, at this time, the trust became settled. The mild-mannered first trustee did not put any funds into his trust. His certificate number was 3 for 125 TCUs, but they remained inactive. And that is, he only receives a payout if the original corpus or a portion of it is cashed out and the trust dissolved. But if it was active, let's see, Mr. Ellis received a distribution for his 125 units representing 25% of the profit if he has activated them by putting his own funds into the trust. So I guess if once he puts stuff into the trust, then his TCUs become active. Because right now, when they're inactive, you only have the certificate if the trust liquidates and a distribution is given. Then he can get the money. But if he puts his own money into the trust, or own assets or whatever into the trust, then they become active and he can get a percentage of the profits. But if it's inactive, he only gets a percentage of the profits if the trust liquidates. Wow, it can easily get up to 500 TCUs very quickly. Interesting. Okay, anybody else have any questions? Okay, then. All right, I'm going to go ahead and stop the recording then.